the 7th module of the ICWA Education Series presented by the Nebraska Court Improvement Project in collaboration with the Nebraska Indian Child Welfare Coalition. In today's module, we will discuss the placement guidelines that are outlined in the Nebraska Indian Child Welfare Act and learn what constitutes good cause to deviate from the preference requirements. We will then dive into the definition of the best interest of an Indian child. It is very important to note that the best interest of an Indian child is different than in our non-ICWA cases, since it is clearly defined in the Nebraska ICWA. Before we look at the descending priority order for placement preferences, we must always first make active efforts to prevent removing the child from their custodial parent or parents. If active efforts to maintain the child's safety in their custodial parent's home are not successful, we then look to place the child with a non-custodial parent if one exists. If a non-custodial parent is not available or appropriate for placement after providing active efforts, we look to the child's tribe for direction. The law has always allowed the child's tribe to establish a different order of placement preferences than is spelled out in the federal or state law that must be followed. Each of the 574 federally recognized tribes have the right and ability to establish their own laws, resolutions, and program policies. One of the most common, but not the only, changes a tribe may make to the descending priority order of placement preferences is to place a higher preference with a native extended family member over a non-native extended family member. This does not supersede a non-native, non-custodial parent's right to placement.
Looking at the placement preferences and how to analyze those. We don't have ICWA placements. There is no such thing as an ICWA placement. And there's placement guidelines that we need to look at, and there's things that we need to consider. And there's placement preferences for all the children that we're serving that are really not that dissimilar from a child who is Native American that we're going to value. It's just that if you're a Native American child, there is emphasis on members of your tribe and other Indian families that will have, I think the spirit of the law is a connection, a tribal connection, a cultural connection that maybe someone else wouldn't have.
Nebraska Revised Statute 43-1508 Sub 2 provides that in any foster care or pre-adoptive placement, a preference shall be given in the absence of good cause to the contrary to a placement with one of the following in descending priority order. A member of the Indian child's extended family. B, other members of the Indian child's tribe or tribes. C, a foster home licensed, approved, or specified by the Indian child's tribe or tribes. D, an Indian foster home licensed or approved by an authorized non-Indian licensing authority. E, a non-Indian family committed to enabling the child to have extended family time and participation in the cultural and ceremonial events of the Indian child's tribe or tribes. F, an Indian facility or program for children approved by an Indian tribe or operated by an Indian organization which has a program suitable to meet the Indian child's needs. Or G, a non-Indian facility or program for children approved by an Indian tribe. For each possible placement, 4 placement requirements must also be considered. 1. whether the child has any special needs, such as medical or behavioral. 2. The placement must be the least restrictive. 3. The placement must be within reasonable proximity to the child's parent or parents to best facilitate reunification efforts and parenting time. And the 4th placement requirement is that the placement must be willing and able to meet the best interests of the Indian child in maintaining political, social, and cultural connections for the child with their tribe and tribal community. Later in this education series, we will talk about how cultural preservation and development plans will be developed with and for placements if the child cannot be placed with a member of their tribe to assist the child and family with this. Let's turn our attention to the adoptive placement preferences as outlined in the Nebraska ICWA. Nebraska Revised Statute 43-1508, Sub 1, provides that in any adoptive placement of an Indian child preference shall be given, in the absence of good cause to the contrary, to a placement with the following in descending priority order. A member of the Indian child's extended family. B. Other members of the Indian child's tribe or tribes. C. Other Indian families. Or D. A non-Indian family committed to enabling the child to have extended family time and participation in the culture and ceremonial events of the Indian child's tribe or tribes. For each possible placement, the best interest of the child must also be considered. The placement must be willing and able to meet the best interests of the Indian child in maintaining political, social, and cultural connections for the child with their tribe and tribal community. The first placement preference for Indian children for adoptive, pre-adoptive, and foster care placements under ICWA has always been extended family members. ICWA has always allowed tribes to create their own definition of extended family. However, if there is no tribal law that defines extended family, then ICWA defines the extended family as a person who has reached the age of 18 and who is the Indian child's parent, grandparent, aunt or uncle, clan member, band member, sibling, brother-in-law or sister-in-law, niece or nephew, cousin or step-parent. This definition includes both Indian and non-Indian relatives.
Misty, we know that there are 574 federally recognized tribes, right? And each one of them has their own culture, custom, ceremony, traditions, ways of being, ways of doing, ways of living. Can you talk a little bit about how at least your tribe, and if you are aware, how some of the other Nebraska tribes operate as far as the family organization and structure?
I guess I'll start out specifically with my tribe. And like I said, we're a part of the Ocheti, Shakoi, and the Sioux tribes. Our tribes were really based on kinship. We have Tawahe and Teoshpai. Tawahe is your immediate family, and your Teoshpai is your extended family. And so, like, with our kinship system, like mom's mom or mom's sister are we call them like your second moms or your mamana. And on dad's side, then dad's brothers are considered dads. And then all of their children are siblings. And then the same thing with mamana, and all of her children are considered siblings. And so that's why it might seem kind of like, wow, this is a huge family when they're talking about my brother or my sister. Well, that very well could be a cousin because of that relationship. And those relationships are super, super important. And that's a lot of what our Lifeways are about, is about those relationships and maintaining those relationships and helping each other. So our tribe, the Sioux tribes, are really, there's so much that is based on those relationships and that kinship system. Other tribes, you go off of clans and have a very, very intricate clanship system, and people have roles and responsibilities based on the clan that they come from. Sometimes those are maternal lineage, or sometimes they're paternal lineage. And sometimes, that tribal membership might even be based on maternal or paternal.
And coming from that Native culture and having that huge extended family, when, say, the parents are not healthy, because I hear from people who are like, well, the parents aren't healthy. I'm like, yeah, but we have all this other family here too. And we need to find them and we need to connect with them. They probably know this kid is there, and they probably don't know how to get in contact and say, hey, I can take them. Because in Native culture, we elevate first cousins to brother-sister status, aunts and uncles to mother-father status. So that opens up a whole bunch of family out there that in mainstream American culture would say that's not an important relation. To us, it is. I know my tribe, we counted down to like third, fourth, fifth cousins, And so we had so much family out there that we could rely on, work with, be with, do things with. And that's why ICWA says, why they have their different levels of extended family and why we want to look at those, because that's cultural. That's part of our culture, it's part of our understanding. It's a no-brainer for us to look to extended family to work with. It's just, I don't think mainstream culture knows that.
It's a different way of looking at it. But for our children, they don't belong to just the mother and the father, and they don't belong just to the grandparents. They belong to the community. And everybody in that community has a responsibility to make sure that the children are safe, that the children are nurtured, that the children are educated, learning. So just think how much healthier that is, to have a whole community that cares about you, that knows who you are, that knows who your family is. It's a beautiful thing.
Nebraska Revised Statute 43-1508 sub 4 outlines what constitutes good cause to deviate from the placement preferences of the ICWA. Good cause to deviate from the placement preferences include one or more of the following: parental preference, child preference if the child is at least 12 years old, extraordinary physical or emotional needs, as is supported by testimony from a QEW, or the inability to comply with the placement preferences after a diligent search. The burden of establishing the existence of good cause to deviate from the placement preferences falls on the party urging that the preferences not be followed. The standard of proof is clear and convincing evidence. A record of each placement of an Indian child must be maintained by the state, evidencing the efforts to comply with the order of placement preferences.
So for placement preferences, we will place with a parent, and then we try to place with a relative.
And then we also have the third placement preference, which is with another member of the child's tribe. And then if none of those is available, then we would place potentially with an agency foster parent who's willing to continue to make connections with the child's family and the child's tribe. And then we need to be documenting each placement preference and why we were unable to make a placement at that level, whatever the safety concerns or the barriers were to that.
The goal of ICWA is obviously to make the best choices available to provide for the best interests of an Indian child and to protect the stability of the Indian family and tribes. Our Nebraska ICWA provides specific guidance on what is in the best interest of an Indian child. Under Nebraska Revised Statute 43-1503 Sub 2, best interest of the Indian child includes using practices in compliance with the state and federal ICWAs, in addition to other applicable laws that are designed to prevent the Indian child's out-of-home placement. Best interest also includes placing an Indian child in a home that reflects the values of the child's tribal culture and is best able to assist the child in establishing, developing, and maintaining a political, cultural, and social relationship with the Indian child's tribe or tribes and tribal community. Keeping in mind that we have specific statutory guidance on what is in the best interest of an Indian child, how can this definition help to define the role of a guardian ad litem in an ICWA case?
GAL is the guardian ad litem who represents the child, and what is unique in Nebraska, because it's not the same in every state, is the guardian ad litem has a dual role to represent best interests and what that child wants if they're at an age where they are able to articulate that position. So it's really important in ICWA cases because it is the only real guidance statutorily where best interest is defined. Otherwise, best interest is a very subjective standard for attorneys to navigate. But in our ICWA statute in Nebraska, it is defined for us. So that sets some parameters for GALs to do their advocacy and additional ethical conflict issues when those may collide, which that could happen if what is in that child's best interest for that out-of-home placement is contrary to what they want. Then you might have to seek another attorney to represent what that child wants, and a guardian ad litem will continue to represent that best interest consistent with the law.
I think particularly as GAL in Indian Child Welfare Act cases, I always say that in a way it's almost easier to define your role because it's defined by statute. And best interest is really to be tailored in accordance with ICWA. And so, as opposed to some sort of subjective analysis of best interest, which happens in most of the cases that we have, you kind of are given parameters to act within. And so in that way, I think it's nice to just kind of go to the letter of the law and look for guidance on what's supposed to be in the best interest of a child and in the best interest of an Indian child. And to me, I think like the crux of that is making sure that a child's maintaining cultural connections to who they are, to their extended family. And I think that's really at the core of what's in the best interest of an Indian child.